Picketers typically gather outside businesses, workplaces, or government buildings, and the First Amendment protects their right to peacefully protest. But what happens when the picket line moves into a residential neighborhood? In Carey v. Brown, the Supreme Court explains the ways that states may and may not restrict residential picketing to protect the privacy of home. Several members of the Committee Against Racism, including Roy Brown, peacefully picketed on a public sidewalk in front of the Chicago mayor's house, protesting his reluctance to facilitate school desegregation with busing. Police arrested the picketers for violating an Illinois statute that prohibited picketing near residences generally, but allowed picketing about labor in front of dwellings that doubled as places of employment involved in labor disputes. The picketers pleaded guilty. They later sued several state and local officials, including Cook County State's Attorney Bernard Carey in federal district court. The picketers asked the court to declare the statute unconstitutional and enjoin government officials from enforcing it in the future. The government officials argued that the state's dual interests in protecting residential privacy while also protecting labor protests justified the statute's content-based speech regulation. The district court granted summary judgment against the picketers, but the Seventh Circuit reversed, declaring the statute unconstitutional. The Illinois government officials then appealed to the United States Supreme Court.